Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about Bill S-7. So this is a Senate bill and it's titled An Act to Amend the Customs Act and the Pre-Clearance Act. I know that doesn't sound terribly interesting. However, if you're somebody who might want to travel into or out of Canada, this could affect you in a pretty serious way. So this is a response to an Alberta case, and I want to cover the case. Unfortunately, it's a case about bad pictures, and so it's difficult to do on YouTube. I might actually end up doing it for locals. However, what that case said is basically that the customs officers at the border can't just search your electronic devices just because they want to. They have to have some sort of standard for that, and it's got to be written in the legislation. So this is legislation that aims to set some kind of standard. Unfortunately, it's going to set a bad standard and one that's going to cause a lot of problems. And so I want to explain how that is. So let's have a look at the legislation, because when we're discussing that, we always want to go to the actual text of the legislation. So this is the proposed Bill S-7, and one of the key provisions is this section here. Documents on personal digital device. At any time up to the time of release, which is when they give you your stuff back, or at any time up to the time of exportation, an officer designated under subsection 2, so a customs officer, may, in accordance with the regulations, examine documents, including emails, text messages, receipts, photographs, or videos that are stored on a personal digital device that has been imported or is about to be exported and is in the custody or possession of a person if the officer has a reasonable general concern that, and basically it's an act or regulation has been or might be contravened, or that there might be evidence of a contravention in some fashion. So that's pretty broad. I mean, in terms of the stuff that they could look at, text messages, emails, receipts, photographs, or videos, lots of people out there have pictures on their phone that they might not want to share with a customs officer. Certainly emails. I mean, I'm a lawyer. Some of my emails and text messages and so forth are not just things that I don't want to share with a customs officer. They're things that I can't share with a customs officer. They're things that are covered by confidentiality and privilege. So that's a concern to me. Now, when they say personal digital device, there's not actually a definition that's been written down here so far of what a personal digital device is, but we can sort of do some little interpretation of our own, right? This almost certainly will include a cell phone. It would include a laptop. It might include a smartwatch or something like that. It might, for instance, include a portable hard drive. It might include all sorts of things. And so basically anything that potentially has data storage is potentially going to be caught up under this. Now, it does say, that it says things that are on that device. However, keep in mind that a lot of devices, like your cell phone, provide access to storage that isn't just on the device, but they also provide access to things that are stored off the device, and that may not be a clear delineation. So that is a potential other concern in terms of if they get your cell phone, can they then maybe gain access to your Dropbox or something like that that's stored off the device but accessible through it. A lot of email is similarly perhaps not stored on the device, but accessible through the device. Now, the really concerning bit here is this sort of subsection that says reasonable general concern. Now, reasonable general concern is a new standard for a search. What I mean by that is that it's not one that appears in any other legislation. Typically in Canada, just about everything relies on one of two standards. Reasonable and probable grounds, or as it's more commonly phrased now in more recent cases, reasonable grounds to believe. Now, reasonable grounds to believe is the standard for them to get a search warrant. So if they wanted to come into my house and have a look at what's on my cell phone, they'd need to do so on a reasonable grounds to believe standard. And that requires, it's more than a hunch and it's more than suspicion, but it's less than a balance of probabilities. And a balance of probabilities simply means more likely than not. So reasonable grounds is not quite as strict as more likely than not. In fact, it can be less likely than not, and they can still meet that standard. But that's the test for getting a search warrant. That's the test for a lot of different things. There's another test that's very commonly used, and that's reasonable suspicion. Reasonable suspicion is still above a hunch or above sort of officer instinct. It requires some sort of identifiable facts that create the suspicion, but it's less than reasonable grounds. So it's an even laxer standard. And I mean, when you think about that, that's pretty lax, right? It's just sort of something that's more than a hunch. So long as they can point to some facts that will, that reasonably can create a suspicion of something, they're probably going to be within that category. This instead is reasonable general concern. What does this mean? Well, there is no case law on it, so there's going to be a whole bunch of litigation. And of course, litigation is expensive, so this is going to cost a whole pile of money. But it also means that it's likely to be over-applied. What is a general concern? Does that mean that they can rely on things that aren't specific to you? Does that mean that they can rely on things like the country you're coming from? Because if so, that could certainly be applied in incredibly discriminatory ways. If you say, this country, we're going to search the digital devices of everyone who's coming in from there, well, then naturally you're going to be targeting certain ethnicities. Is that something that's going to be okay under general concern? Well, we won't know until the litigation happens, and that'll be, who knows when that'll come down the road. What is concern as opposed to suspicion? It's unclear, but it seems that they're trying to set some sort of standard that is below reasonable suspicion. Well, as I mentioned, reasonable suspicion is already a really low standard. If you're thinking about this as, whether this is a high bar or a low bar, this would be the Limbo Championships bar. So what is reasonable general concern? It's probably a bar that's just sitting on the ground. This is really going to open things up to exactly what the courts didn't want, which is just searches based on a whim. How do you say that the officer doesn't have a general concern? I don't know. And what does it mean for a general concern to be reasonable? Again, I don't know. So I have issues with this because when we think about the documents that are on, a cell phone or on a laptop, many of them may be incredibly personal or, in fact, sensitive in other ways. As I mentioned before, I'm a lawyer. I have reasons to not want people digging through my emails because some of them may be privileged or confidential. What if you are coming to Canada as, a foreigner because you want to do business here and you're traveling with business sensitive information on your laptop that you don't want them copying because, of course, it's business sensitive information. Let's say you've got the formula for Coca-Cola on your laptop and you really don't want to have to provide that over to them. It's really sort of unclear as to what protections there are here. And another aspect here is electronic copy. An officer who exercises his power may make an electronic copy of a record or document if it is impossible or practical to seize anything on which the record or document is stored, or if seizing the thing is likely to degrade the record or document or make it unusable as evidence. So they can actually just take a copy of it. And once a copy is made, you don't necessarily know that that's going to be that is going to be something that is preserved properly. Governments can't necessarily be trusted to keep documents secure and safe. I've got another video that'll be coming out on a really egregious example of that from another country coming soon. But they can also potentially just seize the entire document. They can just say, hey, or the entire item. They can say, hey, we're taking your cell phone, we're taking your laptop, and we're going to keep it. This is potentially a really big deal. There is similar language that appears that they're going to be modifying in the Pre-Clearance Act, and so that applies to pre-clearance officers. Now, if you're wondering, who is a pre-clearance officer? Well, if you are a Canadian and you've traveled by air to the United States, you probably did your sort of customs clearance for the States here in Canada, because we have an agreement with the US that allows for that to happen. So this basically says if you're traveling to the States, that they can perform these same searches at those pre-clearance centers. And again, it has the same sort of standard here, but with respect to laws for the United States. Now, interestingly, the U.S. seems to be, from what I understand, and I'm not a U.S. law expert, uh, seems to be using a standard of reasonable suspicion for these same searches. So we're actually establishing a lesser test than what appears to be being used on the other side of the border. So, yeah, this is concerning legislation, and quite frankly, the way to fix it is to replace the language of reasonable general concern with a test that has been used in Canada for decades now. Just replace it with reasonable suspicion. It's not a strict test. It's not hard, and it would provide a little bit more protection for Canadian travelers. Anyway, I wanted to talk about this one because a lot of people have sent me emails. They've seen news articles about it. They wanted me to discuss it. So, yeah, it is a concern. And what it's likely to mean for me as a traveler is that it's likely to mean that whenever I travel, I'm probably going to be traveling with wiped, blanked devices. So that I just take my cell phone and completely blank it out and travel with something that's got nothing on it. So that is that's unfortunately going to be a hassle, but it may be necessary in order to preserve solicitor-client privilege. Anyway, thank you for watching. I hope you found this to be useful or educational. For those of you who've been asking me this question, I hope it's answered the question. If not, let me know in the comments below. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Mark Levier Demour. And at the $20 level, Mick Tane, Mark, Jane Babin Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., and Andrew Elsich. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching, and I hope this has armed you with knowledge.